So the next one ready is Francis Knize.
I certainly, as a citizen, appreciate this fact that this commission is formed and that Connecticut does attest to wanting to reform its judicial system. And I think, as we see a lot of the comments here today, there are severe problems with a lot of the procedures and ethics concerning the judges. My original brief here was actually based on rules that would need a change concerning what I have gathered as a producer, giving a serious role in the interest of justice. I see that to really talk about these rules or any changes would take much longer than 5 minutes. So I'm not going to really deal with them so much tonight. I talk about my own case. I do have a divorce case here in the state of Connecticut. And since that's what the people are addressing tonight, that's what I'm going to testify to and submit later documents concerning that case. Now, in my case...
Well, sir, just to reiterate, I did say that we really aren't addressing particular cases. So if you want to stress instead what you think this commission should be looking at for its strategic plan, the commission members would certainly appreciate hearing that, since we cannot know anything about your individual case.
Okay. First of all, I think that you have to do all you can to create judges involved in the constitutionality of their rulings. Justice Gordon was very vocal about this, and as we well know, there does seem to be a problem, as I can find more consistently in my case. In terms of, so I'm just going to go through some of these rules. In terms of legal assistance programs at court, you should use competent employers who know how to construct every motion properly. My experience is that they don't, and that they know what the heck is going on. They understand some of the forms. They can't answer all the questions. As well, there's a notary public that was signed by the state, and I had to go through a lot of haranguing and deal with the administrative assistant of the courts. To finally tell this notary that he must notarize all documents and not just documents concerning the forms. I think I did actually create that change. So I'm happy to see that it should be written into the rules. I think we have to have a re-examination, especially by the Judicial Review Council, on exactly what misconduct should be. As a matter of fact, I followed this misconduct issue on a local, state, and national forum concerning the judicial conference, on the national forum, dealing with the judiciary committees at both the House and the Senate. And if you want to know more about that, please go online and go to YouTube and look up "In the Interest of Justice," and you will find my testimony concerning all those points. Now, I will have to say that in my case, when I went to the Judicial Review Council and I told them that the Supreme Court panel denied and dismissed my case because they didn't think that my mother being hit by a car was just cause to file a motion late, so the whole thing is dismissed. My family tells me that my mother's going to not live the weekend and I must leave immediately. I put in a motion to file late, and this was denied. This is an inevitable question. This is, as far as the Judicial Review Council is concerned, so what? The judge has discretion. I think we have to re-examine what misconduct is. And I'll talk more. I'll send you more material later about that. This whole idea about up at the appellate court, these 16 copies is extremely burdensome, especially in this electronic age, where we can provide 1 copy or 3 copies or even 6 copies, but why does the appellate court need 16 copies that is so burdensome for the average pro se defendant? And especially if we can provide a disk that all the judges and the clerks have access to, but it's online. There's no reason for that these days. Furthermore, understand it's a system that lawyers can submit motions and all sorts of online, all sorts of legal maneuvers online. And I've been asking the court administration for years now, for 3 years, that it's time to make that same access to the pro se defendants. As I say, I didn't even touch a lot of these points, but I do read them. And I've submitted them before, but if I had 10 more seconds here, I'd say that writs of error must be returned to the judiciary. This is very important. That strict scrutiny must be abided by. You can't just dismiss a case when strict scrutiny was asked for by the court. To prove that strict scrutiny, under strict scrutiny, it's least restrictive remedy to violate a fundamental right. We need that.
You provided these written comments.
I thank you very much.
Thank you very much. Joe Leslie.